Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. I love Canada. I've always regarded Canada as a wonderful place with wonderful people. I spend part of every summer on the St. Lawrence River on the line right between Canada and the United States. Some of my best memories from growing up and some of my best memories with my children come from those waters which we share with the Canadians who live along Lake Ontario and the St. Lawrence Seaway. I also served in Afghanistan alongside several Canadian officers. I respect them immensely. They were disciplined, thoughtful, and extraordinarily professional. Canada and the United States don't just share a border, we share history, heritage, and an unusually deep alliance. In many ways, I regard the Canadian provinces as the British colonies in North America who simply decided not to revolt. Our lineage and our English common law values remain deeply intertwined. As much as I do love Canada, I do not share our president's desire that Canada should somehow become part of the United States. I fully respect Canadian sovereignty and the unique measured path they took on their way to independence from Great Britain. Canada is Canada, and it should remain so. With that said, the closeness between our countries matters, especially when we talk about immigration. Most people would reasonably assume that immigration systems in sovereign countries operate independently. But between the US and Canada, that simply isn't true. The two governments maintain a formal, automated information sharing framework, including the Beyond the Border Action Plan. Canada and the United States routinely share visa and permit decisions, removal and deportation records, biometrics, watch list information, and real-time border encounter data. If someone had an immigration violation in the United States this morning, Canada will probably know about it by this afternoon. And the same works in reverse. It's not superficial cooperation, it's structured, institutional, and extremely comprehensive. One of the clearest demonstrations of this integration is the Safe Third Country Agreement, or the STCA. Canada and the United States have agreed that each country is safe for asylum seekers. As a result, a person is generally required to claim asylum in whichever of the two countries they land in first. If they reach the Canadian border after traveling through the United States, Canada will usually return them to the U.S. to pursue asylum there, subject to narrow exceptions. And vice versa. That framework requires that Canada and the United States share data on asylum applicants, travel routes, timelines, and identity information. It forces the two asylum systems to operate in sync because an asylum officer in either country needs to know where the applicant has been and what claims they've already made. The STCA is a clear example of how the US and Canada view their shared border not as two separate entry points, but as a coordinated migration and security space. As I was growing up, I was always told that the border between Canada and the United States is the longest unprotected border in the world. That is largely true, but only because of this closely coordinated migration and security space. But this can also have negative ramifications for those seeking to immigrate to the United States or Canada, especially in an asylum type situation. If someone is removed from either the United States or Canada, it's going to make it a lot more difficult to enter either of the other countries. For example, a recent expedited removal from the United States is a major integrity flag for the Canadian Border Services Agency. Even if a traveler holds a valid Canadian visa, they should expect an automatic referral for secondary inspections, detailed questioning, and a real possibility of refusal. In particular, if the expedited removal from the United States involved misrepresentation, Canada can bar that person for 5 years. However, that bar is subject to a waiver. If U.S. authorities suspect immigrant intent or noncompliance, Canadian officers will almost certainly see it the same way. And because the STCA links both asylum systems, Canadian officers are primed to rely heavily on U.S. findings. That's what happens when two sophisticated immigration systems share data, security objectives, and expectations of compliance. Now, as I mentioned earlier, Donald Trump has significantly damaged the relationship between Canada and the United States. It is not clear for how much longer these systems are going to be integrated. But for now, you can be pretty sure that the Canadian and U.S. immigration agencies are going to be aligned. In closing, Canada is a remarkable country and arguably America's closest ally. But that closeness isn't abstract. It plays out on how both governments manage their borders and immigration systems. If someone has a negative immigration event in the United States, it does not stay in the United States. Canada sees it, they will evaluate it, and frequently they will act on it. If you want to dive deeper into how U.S. immigration issues affect cross-border travel or asylum eligibility under the Safe Third Country Agreement, I highly encourage you to schedule a consultation with Charles International Law.